Hi guys, give me a second. Let me arrange the frame. Good evening, good evening. How are you all? Good evening, everyone. So, welcome to Legal Current Affairs. And this is something that we conduct every Friday, and it is an important lecture partially because we know how important current affairs are, right? And these are good evening, good evening. These are extremely scoring, and students are not really able to figure out what to study, what not to study. So, by giving you these weekly affairs every week, we give you some very important piece of information along with the idea of how to deal with them or what to study alongside. So it's not just current affairs that you need. The newspaper information is never enough. You have to complement it with certain other things, and that is what we are going to do, right? So along with these topics, I'm going to tell you what additional things that they are there that you need to remember. So you would make or incorporate that in your notes as well. Okay, so how are you all? I'm good, thank you so much. Happy monsoon. And tell me something interesting. What all is happening at your end? Preparation, anxiety, panic attacks, anything that you wish to share with your old Nivedita ma'am? Yes, so what is happening? Good evening to you all. We can continue with that later. Okay. Right. So let us begin. Before we begin, you should know that these are the success stories. Everything is interesting. Okay. Everything that I just quoted, anxiety, panic attacks, and everything. So these are the students that have managed to, Arman, you need my help? Okay. Tell me, how can I help you? You can post your day by day self-doubt increases. Self-doubt increase is not something unusual. Okay, people doubt themselves before entering or enduring upon a new journey. Whenever they're about to do something really important like a competitive exam or stepping into another phase of life such as marriage, etc. So everybody gets nervous, everybody gets scared. And remember one thing, and remember it always: being scared or feeling a little insecure or getting the sense of fear before you were about to do anything is not a bad thing, guys. It's never a bad thing. If you are scared, it's not that you're doing something unusual. There's no such thing as fearless. Everybody is scared. Everybody feels discouraged. Everybody, feels insecure. The point is that while you are feeling all those things, you need to keep on doing what you are doing. And that's what makes you courageous. Courage is not feeling not fear. Okay, courage is not about feeling never scared at all. It's not about being fearless, not scared of any goddamn thing in the world. No, there's another accurate interpretation of being courageous. Courageous means feeling scared, feeling insecure, but despite all those feelings, continue with what you're doing and excelling in it. That's what makes you courageous. So don't be scared that you are scared. It's okay if you are scared. It's okay if you are insecure. If you're okay if you have self-doubt. Just keep on doing what you're doing and everything will turn out to be excellent. And I'm telling you on a personal experience, an experience of a lot of years. ठीक है? So that's absolutely fine. डरने में कोई बुराई नहीं है, डरने में कोई कमजोरी नहीं है, लेकिन डर के बावजूद भी अगर आप वही चीज करते रहे जो आपने ठान रखा है, वो आपको फियरलेस और करेजियस बनाती है। इस बात को हमेशा ध्यान रखें, एंड दैट इज समथिंग दैट यू should always incorporate while you when you are about to do any significant thing in your exam or in your life, whatever it is. Okay, job, marriage, relationship, this competitive exam, etc. Okay, so we would be releasing the success stories and interviews with these candidates very soon, and as you can see, they have managed to get into the most significant colleges of the country, and you would hear from them their experiences, their stories, what they did, what they did not do, what could you do to be at that stage, right? Never a problem, Alfea. How much hours should you read to clear CLAT? Do you mean study or just basic reading? See, hourly study is subjective. It is not the hours you need. It is the completion of syllabus. So you manage it on your own. How much hours do you think you can give to your preparation? The time that you are able to extract without jeopardizing anything else, be it your academics, your social life. So whatever amount of time that you can take out without feeling burdened and bored, that is your amount. That is the ideal amount of study. There is no fixed figure as to denote. Arman, how do I help you? If you just say, please help me, I mean, what, are you hanging off a cliff or something? How do I help you, buddy? Tell me. Okay. Stuti, if you don't want to take mock on laptop, get a printout and get your eyes checked. Nahi Arman, no. Jamia exam has already passed. It has already been taken. Jamia has a different exam. You said taters for BHU thing, I think, but not Jamia. Jamia has a separate entrance. Stuti, take a printout and then attempt the mock on a hard copy instead of taking it on a computer, and get your eyes checked. It's not a good thing. Yes, moving on, sorry. Moving on, so the first segment of today is soldier cannot claim disability pension based on medical examination conducted years after his discharge. So the case name is Arman, I will come back to it. Maybe the team will help you. Okay, maybe the team will help you. I'll come back to it. So the name of the case is Union of India and others versus ex-SEP R. Munnuswamy. Okay, so they're not completed facts, but the crux of the case is that the Supreme Court has held that to claim for a disability pension, like there is a separate pension that the defense services gives to its employees if they have sustained an injury due to their service, or while their years in the service there is a certain injury that they have sustained due to the nature of their job, then the defense takes responsibility for it and gives them an additional pension that is called a disability pension. Okay, that is called a disability pension, but there are several claims arising out of a disability pension as to what are the situations in which it can be given, what has to be done, what are the formalities, when should it be given. So in a previous case that we discussed last time, it was made clear that disability pension can be given to a person who sustained the disability during the service or while engaged in that service, while engaged in that role. The disability should have arisen because of the job, not because of any other factor. Only then the defense is liable to pay an additional amount, not otherwise. Now, another thing is, if a medical examination is conducted years after the person was discharged due to the disability, and then turns out that there is a disability because of which he was discharged, or any disease or any onset of any problem that arose because of the military, because of the duty that he gave or his service during the military, then he he is not entitled to the pension. If you are claiming a pension, if you are claiming an additional benefit, Tusha, I can do it. Just let me finish it in English first and then I'll translate. Okay? So, while a person is engaged in the service, there are certain things, exposure to chemicals, exposure to harsh atmosphere. For example, people being located in Leh Ladakh, extreme environment, extreme atmosphere causes a lot, takes a lot of toll on a human body. So if because of that toll, a person has gotten a condition which is a disease or something like that, okay, so you cannot take a printout, take a screenshot. There are several ways, sweetheart. If you're taking it on a phone, take a screenshot, then take a printout. Okay, I know that you cannot download them. So why don't you take it? It's technology is so goddamn advanced right now. Just take a screenshot, print them out, and then you can go about it, right? Do that way. Yes, so what was I saying? So if a person has sustained, or if a person has gotten sick because of the condition or because of the military service or because of the harsh environment of the military, etc., then the examination has to be done like regular examination. People are subject to regular examinations in the defense services anyway because of the nature of the job, right? So if during those examinations nothing has if nothing shows, there is no disease, nothing onsetting, nothing like that, then maybe you're not catching a disease. But after several years of your discharge, if you have figured out that, oh my god, there is a disease that I have somehow okay, so Hariom has enlightened us with a very relevant information. They are downloadable after you submit the mock. Okay, so after you completely take the mock, they can be downloaded. That's good. That's good. Right. So you cannot postpone it. There is a statute of limitations, metaphorically that applies. Now, what exactly is limitation? That becomes important in this segment. Let's take for an example that there is a person whose grandfather was engaged in a certain fight. Okay, let's say that there is a person A and there is another person B. Now try to understand this concept because it is important. Okay, they have not mentioned the word limitation, but they have actually used the metaphorical interpretation of the statute of limitation. So there are two people, A and B, and they are, there are certain Bollywood people and they just don't like each other. They don't like each other at all. A hates B and B does the same, vice versa, absolutely. Now, B keeps on causing troubles to A and A does the same. Someday, B actually, transgresses, like he does it in excess, because of which the mere altercation now becomes animosity or they become enemy. And because of this tumultuous relationship, they end up hating each other. And in one such fight, B breaks A's bone. Okay, and he breaks it in such a manner that A is paralyzed for life. Now, A has a generation. A has a son, the son has a son, and A's great-grandson is E. A's great-grandson is E. Now, let's say that B's great-grandson is F. After several years, like several decades, obviously when we are talking about great-grandson, we are talking about decades in between. So if E decides to avenge his great-grandfather by breaking F's bone in a manner to cause him permanent paralysis, will that be fair? Do you think it is fair to carry such hatred? Or if E decides that, F's great-grandfather broke my great-grandfather's bone, now I will institute the suit. Now I will file a criminal complaint of grievous injury. After decades of injury, he decides to file a case and lodges an FIR against F's family for breaking his great grandfather's bone. Now, if people are allowed to do that, do you think the cases will ever end? If I start avenging my great grandfather, everybody will do it because people are vengeful. Let's face it. People are vengeful and they would do anything just to manage that, that person should be punished. What if I don't like somebody right now and I don't have time with the job and everything going on? Let's say that you don't like somebody and you cannot file a complaint because you don't have time. You're preparing for a competitive exam. Now you would have a college later on, 5 years of college, then hunting for a job, situations like that, then marriage, then children. So you think that I don't have time for all these court kacheri right now. What I'll do is when I'm retired and I don't have absolutely anything to do, then I'll file a case, then I'll make him pay. Is that fair? No. Law cannot sit for you and wait for you to report your case at your convenience. Right? And that is where the statute of limitations come into picture. You can file for your right. You can claim your right. You can definitely address your grievance, but you can only do it in a given set of time. Law will not wait for you till you have time to file for a case. Hence, there is a certain time limit, both for civil. The time limit does not apply in criminal although, but after a certain while, if you take too much time to lodge a criminal complaint, the time has expired. The court will dismiss your case. In civil especially, there is a time limit for everything. If there is a case related to property, if there is a case related to contracts, if there is a tort, if there is a minor injury, if there is anything that is civil in nature, there is a certain time in which you can file the complaint. If you do not file the complaint within that time, after that you cannot file a complaint. That is what we call limitation. That is the concept that has been used in this case. Does everybody understand? Is there any problem whatsoever? Anyone? Hurry up, hurry up, hurry up. No? Okay, I'm assuming that you don't have a problem. Right? So see, his medical examination was conducted 20 years after his discharge. And after 20 years, he says that because of the because of the military service, the medicinal condition or the seizure or whatever it is that happened increased manifolds. And that is why he should get disability pension. Okay, in Hindi. So guys, I have already explained everything in English. I'm just translating what I said. I cannot go back and forth again, Rishi. So it would be, really helpful if you try to understand in English because CLAT, after all, is an English exam. You have to read and understand English. So it is a good practice that you try to understand what I'm saying in English only. I can definitely translate it because for your own benefit, you should try and understand what I'm saying in this language. Okay. So, but I'll translate nevertheless. तो मैंने आपको पढ़ाया है कि इस केस में ऐसा हुआ है कि अगर आपको कोई ऐसी बीमारी हो जाती है या कोई ऐसी इंजरी हो जाती है जो आपकी जॉब की वजह से हुई, स्पेशली डिफेंस सर्विसेज में, तो मिलिट्री या फिर कोई भी डिफेंस सर्विस जो होती है, नेवी, आर्मी एंड एयरफोर्स, वो आपको एक डिसेबिलिटी पेंशन देते हैं, एक एडिशनल बेनिफिट बाकी और बेनिफिट्स के साथ, क्योंकि आपको जो चोट लगी है, जो डिसेबिलिटी आपने इनकर करी है, वो आपकी जॉब की वजह से की है, आपकी सर्विस की वजह से की है, ड्यूटी की वजह से की है. तो डिफेंस की भी ड्यूटी है कि वो आपको उस डिसेबिलिटी के लिए जीवन भर कॉम्पनसेट करे. दैट इज कॉल्ड डिसेबिलिटी पेंशन. अब इस केस में ये होल्ड किया गया कि भाई डिसेबिलिटी पेंशन को देने से कोई मना नहीं करता, लेकिन डिस्चार्ज के 20 साल बाद या फिर अनरीजनेबल अमाउंट ऑफ टाइम के बाद अगर तुम एक मेडिकल एग्जामिनेशन करवाते हो और तुम्हें पता चलता है कि भाई ये जो नई बीमारी है या कोई ऐसी प्रॉब्लम है, ये उस चोट की वजह से है जो शायद तुम्हें कभी आर्मी में लगी थी, और फिर तुम क्लेम करते हो कि नहीं मुझे भी डिसेबिलिटी पेंशन चाहिए, तो नहीं मिल सकती. ठीक है, दैट इज द केस. यहाँ पे स्टैच्यूट ऑफ लिमिटेशन आ जाता है, जिसका मतलब है कि आपको अगर अपना कोई भी ग्रीवेंस एड्रेस करना है, अपने राइट के लिए लड़ना है, या फिर कोई भी शिकायत करनी है, आपके राइट को इन्फोर्स करना है, तो वो आप एक सर्टेन विंडो में ही कर सकते हैं। एक टाइम लिमिट दी जाती है हर केस को इंस्टीट्यूट करने के लिए। अगर आपने उस टाइम लिमिट में केस को इंस्टीट्यूट नहीं किया तो लिमिटेशन क्रॉस हो जाता है, फिर आप केस नहीं कर सकते। और ये लिटिगेशन को रिड्यूस करने के लिए है, ताकि कोई भी आदमी बैठा ना रहे अपने राइट्स के ऊपर। जैसे अभी तुम्हारे पास टाइम नहीं है, तुम्हें किसी से दुश्मनी है, तुम उस पर केस करना चाहते हो, उसने चोरी वोरी कर ली, पेन चुरा लिया, बुक चुरा ली, और तुम सोचते हो अभी तो टाइम नहीं है, अभी तो मैं क्लैट दे रहा हूँ, फिर मैं कॉलेज में जाऊंगा, फिर मैं नौकरी हंट करूंगा, फिर मेरी शादी हो जाएगी, फिर मेरे बच्चे हो जाएंगे, फिर मुझे उनकी शादी करनी पड़ेगी, अरे अभी तो लाइफ बहुत ज्यादा डिफिकल्ट है, तो जब मैं रिटायर हो जाऊंगा, बिल्कुल खाली बैठा हूंगा, तब करूंगा इस पे केस, एकदम फ्री बैठ के लड़ूंगा। तो अगर तुम ऐसा करने की सोचते हो तो तुम नहीं कर सकते, राइट? क्योंकि लॉ तुम्हारे लिए बैठा नहीं रहेगा, तुम्हारे पास एक टाइम लिमिट है। जैसे हर चीज को रिटर्न करने का एक टाइम विंडो होता है, यू कैन रिटर्न अ प्रोडक्ट ओनली विद इन अ सर्टेन टाइम फ्रेम। So if you are given 30 days to return a product, you have to return it within 30 days, because after 30 days the products actually get old. और कौन उसे यूज करेगा? कंपनी को भी नुकसान हो जाएगा। That is what limitation is. Okay? Everybody clear? Good. Supreme Court stays Karnataka High Court judgment that allowed trial for husband for marital rape. Now everybody who understands marital rape and everybody who knows what the verdict of Supreme Court is should know that the Supreme Court did not confirm anything. I understand Hindi में if you listen everything दिमाग में बैठ जाता है. So, but I cannot be bilingual, like, you know, it has to cater to everybody. Guys, everybody, and I understand that while Hindi is actually very manageable and understandable and you connect more with your mother tongue, it's not everybody's mother tongue. You know, people understand English because there's no other option. So there are students who come from different regions who do not understand Hindi, and we have to understand their concern also. So we make it and try to I try to communicate in the language that is understandable to everyone. Got it? So anybody can say, ma'am, if you explain this to me in my mother tongue, I would be able to understand better. Obviously, but I don't know how to speak any other language than Hindi and English. Right? So try to understand. I can translate whenever you want, but let's try to stick to English because, hey, that is what our syllabus and exam is going to be in, right? So if anybody has read the Supreme Court verdict on marital rape, you would have understood that Supreme Court did not come up with a conclusive judgment. There was a division bench. One said marital rape should be an offense. Another said it should not be an offense. And there was a tie. And there was nobody else to break that tie. Right? One person said something, another person said something. Now, third person could have either gone with either of the people. But since there was no third person, there was kind of a tie. So, we don't have a confirmed position on where we stand on marital rape. Now, what exactly is marital rape? See, when people are together as man and wife, sexual activity between them is a routine, a usual course. That's how a marriage works, right? Now, the thing is that there are situations in which husband may force himself upon the wife. While she may not resist or fight like a stranger, but she would absolutely be ready for it is not necessary. So she might surrender without, without a vigorous retaliation. But she might not consent to it. For example, if you remember the Mathura case that I taught you, I told you that I taught you that in Thursday Thriller. So what happened in Mathura rape case was, Mathura was a child of 14 years and she came from an underprivileged section of society. She was extremely poor. She came from scheduled caste, poor, not literate, and people from that background are usually afraid of people in authority, especially the police officers, because police officers torture them on a regular basis. And the fact that, oh my God, I'd be put into jail and my life would be over is something that scares the hell out of them. And that is why, people in position, people with power are an anathema to them. They try to stay away from them as much as possible. Are you getting my point? So when that rape happened, when the man was raping her, a sturdy, fat Marathi man who could very easily overpower the child of 14 years, she did not retaliate as much because she could not retaliate. She was scared. She was a child. She was terrified. She was traumatized, and her physical capability did not allow her to do anything. The maximum she could do was submit to the act without saying anything because there was no other option, right? And this involuntary surrender was interpreted by the trial court as consent, that if she did not fight for it, if her clothes are not torn, if she is not injured, if she is not fighting, if she is not saying no, no, no over and over again, it means that she said yes, right? That was the Mathura case. Everybody knows that, right? Yeah, it's sort of like that. So you watch Thursday Thriller Mathura case if you want to get into the deep thing. Okay. Now, in a marriage also, sometimes when a man forces himself upon his wife, there is no retaliation, but there is no absolute surrender because they're usually involved. Right, the sexual activity between them is not out of ordinary. It happens, and if once in a while a man forces himself, the lady does not really retaliates. Now the question is, if a husband is forcing upon himself upon his wife, should that be tried? Should that be construed as an offense between a between a couple where sexual activity is an ordinary thing, that they are related that way? So if it happens forcefully once in a while, for example, if a child is not eating is necessary, mother forcefully feeds the child, no, you have to eat it. So it is not as if mother is committing assault or battery. No, she is just concerned for the child. That is one of the interpretation or one of the uh, uh, favorable argument given of for not criminalizing marital rape. Now, in this situation, feeding a child, feeding a toddler is a different scenario altogether. But forcing upon a lady is violating her everything, her self-esteem, compromising with her, modesty, completely taking her as an object, not treating her as an individual, as a human being who has feelings, who has, discretion over her body. She can say no. She can say no to her husband, even though he is her husband. She can say that I don't want to do it. She can very well say it. And if the husband, despite that, forces himself upon her, she should have a right to lodge an FIR against him. Now, the argument against this is that if a woman is allowed or marital rape is in fact criminalized, women are anyway taking advantage of the laws made for them. For example, dowry act, domestic violence act, all these acts are made in favor of women misuse them. They try to seek vengeance using these instruments, and marital rape can very easily become an instrument of misuse because there is no way to prove it. Rape can be proved. How? Because forceful rape incurs injury on the private parts of a woman, right? But if a husband wife are regularly involved in that kind of activity, there is no way to prove that husband forced himself on the lady. There would not be a significant sign of retaliation. Again, like Mathura case, clothes won't be torn, there won't be any injury, there won't be any beating, there might be a little bit of beating. But if a lady says that I was raped by my husband, the law has no other option but to believe her, because there is no way husband can say no and be believed. Are you getting my point? तो अगर एक लेडी कहती है कि मेरे हस्बैंड ने मेरा रेप किया है, तो तुम इस चीज को प्रूव नहीं कर सकते और तुम इस चीज को डिस्प्रूव भी नहीं कर सकते. तुम वाइफ तुम उसकी बात को किसी भी तरह से प्रूव नहीं कर पाओगे कि उसका रेप हुआ है. But you cannot completely believe the husband that rape did not happen. So in that kind of situation where something is absolutely non-provable, how do you criminalize an act? You have to completely depend on the words of the wife, who can very well be misusing her. Oh, sorry, misusing her power or misusing the law. What would happen to a guy who did not do anything but still was implicated by a vengeful wife who just wanted to get back on him, get back to him? So that is why marital rape is not criminalized. But Karnataka High Court in a trial actually uh, punished or allowed a trial for of a husband who was implicated for marital rape. So the trial is not allowed because marital rape is not an offense unless it is done with a woman who is less than 15 years of age. So if you have taken a wife who is less than 15 and less, and then you get involved in a sexual activity, then it will be a rape and it will be a marital rape. So marital rape only in this category is punishable, not otherwise. Got it? So, but despite this position, Karnataka High Court allowed the trial of a person who was implicated or who was charged with marital rape. Now, this trial was appealed in Supreme Court, and Supreme Court put a stay on that trial unless they come up with a more confirmed position on this offense or on this situation. Do you understand completely? I used Hindi also. Got it? So May 11, as I told you, Delhi High Court, not Supreme Court, Delhi High Court, my mistake. So Delhi High Court delivered a split judgment on the constitutionality of marital rape, and there's no confirmed position. There are appeals filed in the Supreme Court, but there's nothing sure that we know about what is going to happen. Now, before we proceed any further, you should know that there is a detailed exam analysis of MHCET Law 22, and we would be discussing the expected cutoff, the difficulty level, the amount of good attempts, and everything related to an exam. And it will be conducted, as you know, on the day of the exam. Right? So it will be conducted by Abhimanyu sir and KD sir, and be there to understand where you have landed yourself in MHCET. Good afternoon. How are you? Right? Good. Now, earlier suit dismissed on technical grounds without adjudication on merits would not operate as res judicata. Now, this news itself is not important, but the concept incorporated or embodied in it is important. Okay, why is it important? Res judicata was asked in your exam in CLAT 21. Okay, it's one of the most crucial concept of civil procedure, one of the most important, but when it comes to your competitive exams such as CLAT and any other law entrance, it does not hold as much importance. But since it was asked in 2001, we have to take into consideration that it might be asked again. Res judicata passage was relatively simple than the other passages that were asked in 2021, but students, as soon as they saw the word, got completely confused as to the fact that we have never understood, we have never read this thing called res judicata, what is it, and they chose to leave the passage. This is something that you can avoid. Even if there is a fancy legal word that you might not have ever heard before, you can just read the passage. You can solve it like any other unseen passage that you did in your school, right? And you would be surprised to know that you will be able to solve it. I'm not sure. Oh yes, everything is important. I don't teach anything irrelevant. Don't worry. Nothing irrelevant. Everything is important. Now, what exactly is res judicata? Understand it through an example. Upma, I just told you. Yes, it is important. Yes, it is. Okay. They can give you the principle, just this principle, and they might give you a factual situation. So let's say that A files or A institutes a suit against B. Got it? Now, there is a certain issue about a land as to the ownership of the land, and this suit is instituted in court C. Now, this issue is the ownership of the land. Now, you do realize that in a city, there are multiple civil courts, right? There's not just one civil court, there are multiple, many. Okay, there's one district court, but there are several civil courts. Ownership of this land. Now A claims that he is the owner, but B is already possessing the land, and he says that he is the owner. A files a case against B, claiming that he is trespassing on this land, and it is his land that he is trespassing upon. He is the true owner. Now court C gives a judgment in favor of B. Okay. Now remember the fact, the parties in this case are A and B. The issue at hand is the ownership of a land. Got it? Now since A did not get a favorable judgment from court C, A institutes another case in court D, another trial court. Sorry. Another trial court. Got it? So A institutes the same case, same parties against B, same issue, nothing changes. Like he has instituted the same case, exactly the same. Nothing has changed whatsoever. The complaint hasn't changed, the claim hasn't changed, the remedy hasn't changed, the issue that was complained about hasn't changed, the party hasn't changed, nothing has changed. It is absolutely the same. So he has lodged the same case in the court of similar jurisdiction. Now this is where res judicata comes. If you have instituted a case with a certain party, with a certain issue, with a certain cause of action in one court, you cannot issue the same case, same parties, same issues, same cause of action in another court of similar power or similar jurisdiction. Res judicata will apply. Why is this issue, or why is the principle of res judicata so important? Because if we do not impose a principle or a limitation like res judicata, people will keep on instituting the cases in different courts, so until they get a favorable outcome. This court is not favoring me, I'll go to another court. Same court, matlab, there are many courts with similar powers. That's what I'm referring to. He can always appeal, but he cannot go to the same court. Let's say C, D, E are similar civil courts. They all have same powers. So if A has not received a favorable outcome from court C, he cannot go to court D, he cannot go to court E with the same issue at hand. Did you understand? Or did I confuse you? Tell me. Hurry up. Guys, hurry up. Did you understand or not? No? Okay, I'm not receiving an answer. You did? Understood? Good. Got it. Now, let's change this issue from ownership to possession. If A changes the cause of action from ownership to possession, now he is not fighting for the ownership, he is actually fighting for the possession. Now he gets a different cause of action. Every cause of action gives a person a different right to sue. Now since he has changed cause of action, he can definitely lodge another case. But based on the same cause of action with same party, same issue, he cannot lodge the same case in the same forum. He can appeal against the judgment, but he cannot lodge the same case in the same forum. But if he changes the parties, if he changes the issue, if he changes the cause of action, then he can do it. Now, the situation in this case was that if there is a suit that is dismissed on a technical ground, for example, if A instituted the case in court C and court C said, buddy, I am a family court, I cannot deal with this property case, please take it to another court. That means that the court or the court case is dismissed on a technical ground. Technical ground being the adjudication. Okay, so I don't have the jurisdiction, I don't have anything. So if a case like this is dismissed on a technical ground, for example, the paper was not complete, or for example, the court did not have jurisdiction, or they did not have the power, the forum was different, anything, any technical ground, procedural defect. So if the court case is dismissed on a technical ground, res judicata will not apply, meaning thereby that A can institute the same case in the same court or the court which is appropriate. That is what this case means. Ownership means owning the property. Possession means keeping the property under possession. Got it? Anybody, any doubt whatsoever? I'm assuming that you don't have a doubt. Good. Moving on. Earlier, we have already discussed it. Moving on. Primary object of habeas corpus petition for child's custody is to determine in whose custody the best interest of the child will be. Now, habeas corpus, everybody understands what habeas corpus is. Mind you guys, habeas corpus is an important part of your syllabus. Constitutional writs are very important. So, what exactly is habeas corpus? Habeas corpus is only one writ where the rule of locus standi does not apply. So, habeas corpus literally means produce the body. So, if a person has been detained illegally, or if a person is under unlawful detention can be committed by anyone, a private individual, a person in authority, a police officer, father, mother, grandfather, because they don't want their girl to marry somebody from another caste and they are keeping her inside the room. That is also unlawful detention, right? So any detention which is not authorized by law is unlawful detention. If a person is being held in an unlawful detention, he can file for habeas corpus, or anybody on his behalf or on her behalf can file for habeas corpus, which means a release order. Terminate that unlawful detention immediately. Right? So if there is a child who has a custody, who is being involved in a custody battle, father and mother both want to keep him, but he is with father and mother has filed a writ of habeas corpus that he does not let me meet with my child and he does not let me talk to my child, etc. All this. So habeas corpus can be instituted for obtaining a child's custody or for seeing the child. But custody will only apply and the writ of habeas corpus will apply only if the court feels that it is in the better interest of a child to meet with another parent. Now understand this by an example. Let's say A and B are divorced and they got divorced because of A's extreme alcoholism, right? So A is abusive and he's an alcoholic, because of which B sought or took a divorce from him and now she is keeping their child C. Now A is constantly pressurizing B to meet with C. I want to meet my son, I want to meet my son, give me a time. I want to meet my son and you cannot keep me away from him. I am his father, I am his father. And B does not want C to meet with A. Why? Because A is not a right person before whom a child should be exposed. Like he's an alcoholic, he's abusive, nobody can say what he can do. So she does not let A meet with C. A files a writ for habeas corpus, which says that there will now be a court order that C should come before A, or B should allow C to meet with A. Now in this case, court will try to examine the interest of the child. Is it in the child's interest to meet with his father or to stay with his father? If A is keeping the child to herself, not exposing him to his father's bad habits, is it a wise option? If it is, the writ of habeas corpus will not lie. Did you understand or not? So before declaring whether or not habeas corpus will apply, they would first see if it is in the child's interest. not otherwise. Okay, then the issue of child's custody along with habeas corpus will be sought. Locus standi is the right to institute a suit. So if I have sustained an injury which was caused by C, only I can complain against C. Nobody related to me can complain against C. Why? Because the injury was mine. I got hurt. So only I have the right to file a complaint. Nobody else can. And this is what we call locus standi. In the rule of habeas corpus and PIL, public interest litigation, the rule of locus standi does not apply. They are the exceptions. Okay. Got it? Now, plea to declare virtual hearing as fundamental right listed before bench led by the Justice D.Y. Chandrachud. Now, the judgment is not yet out, but you should know what the case is all about. So, in amidst a situation of pandemic where nobody knows for sure what is going to happen, the courts, no, he can't. No, he can't. Minors cannot take that kind of decision. It is for the court to determine who is the right person to hold the custody. The child's wish definitely hold an importance. Mother and father's wish do not. If a mother, obviously both of them would want to keep their child, but the interest of the child, the choice of the child, everything is taken into consideration. If the child wants to stay with the father, but father is not the right custodian, then the court will decide otherwise. The paramount thing in custody matters is the interest of the child. Okay, where are the child's best interests lie at? So that would determine the ultimate custody. Okay, so the judgment is not out yet in this case, but you should understand what is it about. In a situation of pandemic, amidst everything, the courts are not completely functional. There might be something which allows a man to not travel to that does not allow a man to go to the court because of any disability. Let's say that he's completely disabled, he cannot attend the court. So virtual hearing, or a hearing conducted by a technological means or on a video should be declared as a fundamental right, considering everything that is going on. So there's actually a new interpretation that is sought in this case, that if a person wants to file for a virtual hearing because of any reason, he might be hospitalized, he might not be able to move, he might be in another country, but he's still a citizen of India, and by that right solely he gets a right to institute a case in the Supreme Court or to go to the Supreme Court, to move the Supreme Court, but he cannot come because he is not in the country. So anything that prevents a person from going to the court physically should allow that person to get involved or participate in a virtual hearing, and that should be his fundamental right, because suing or fighting or getting a right enforced is also a fundamental right. So the procedure to enforce the fundamental right should also be a part of it. Virtual hearing is a process to enforce your fundamental right, because you have to go to the court and hearing is compulsory. So if you are fighting for a right and you cannot do it physically, you should be able to do it by video conferencing, and that should be protected by the Part 3 or the Constitution of India. That is the plea. Let's see what Nageshwar Rao and Justice D.Y. Chandrachud have to say about it. As soon as the judgment is out, we'll discuss it. Okay? Right. So that's it for today, guys. Thank you so much for watching. Everybody has to like the video, comment on the video, share and subscribe to our channel if you haven't already. Right? And I shall see you again very soon. Till then, everybody take care. Bye-bye. Thank you so much. Is there any doubt anybody wants to ask before I end the lecture? It would be a fundamental right under Article 21. 19 also. 14 also in some situations. Okay, golden triangle, 14, 19, 21. Okay guys, thank you so much. Bye-bye. Take care.